The basic structure doctrine, a term that is alien to a majority of Kenyans, was one of the outstanding fixtures in the judgment delivered by the Supreme Court today. In an upset to the respondents, 6 out of the 7 judges held that the basic structure, which prescribes a strict process of amending the constitution, was not applicable in Kenya. The judges declared that the country's constitution had enough safeguards to guard it against mutilation, and therefore the country did not require to import foreign doctrines to protect the constitution against unwarranted amendments. Citizen TV's Sam Ogina reports.
Citing 3 failed attempts at amending the constitution through a popular initiative and a total of 21 attempts over the past decade at effecting changes to the supreme law, the judges held that the basic structure doctrine was not applicable in the country's constitution, contrary to the findings of the High Court and the Court of Appeal. The basic structure doctrine dictates that the constitution of a sovereign state has certain characteristics that cannot be erased by its legislature. This essentially making it difficult to pass amendments to the constitution.
What Kenyans desired is a balance between rigidity and flexibility, as reflected in the tiered amendment process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened protection, but still open to amendment.
In invoking the basic structure doctrine to the Constitution, the High Court and the Court of Appeal held that to institute any changes to the Constitution, the principle of civic education, public participation, constituent assemblies and referendum was a prerequisite to all clauses of the Kenyan Constitution. This ostensibly to protect the Constitution from ambitious amendments, but the Supreme Court held that contrary to the Independence Constitution that was mutilated by the political class, the 2010 Constitution had self-gatekeeping measures that were restrictive. This therefore described the basic structure doctrine as a needless foreign doctrine.
I find it difficult to justify this judicially created fourth pathway of amending the Constitution founded on the basic structure doctrine.
And to suggest that the proposals were a dismemberment of the Constitution, are they so? In my most respectful view, these words were an overkill.
Nonetheless, Justice Mohammed Ibrahim was in the minority, holding that the basic structure doctrine was applicable to the Kenyan Constitution.
I do not think it is necessary that before application of a doctrine or legal principle, the same must have universal application.
With majority judges ruling that the basic structure doctrine is not applicable in Kenya, the path of amending the Constitution will remain defined by Chapter 16 of the Constitution, which provides for amendments through the parliamentary route or the popular initiative. Sam Ogina, Citizen TV, Nairobi.